his son has killed someone. There is a young man in the middle of the road. This guy ain't no shot. This guy's an asshole.
He shot him in the back of the head. If there was an intent to kill, when you put a gun to somebody's back of the head, there's an intent to kill there.
Okay, what's the problem?
I killed my son.
You what?
I killed my son.
How did you kill your son?
I strangled him.
In March 2021, 39-year-old Tito Roman was fatally shot at a motel on San Antonio's Northwest Loop, 410, following a dispute over a Ford Bronco. Douglas Skaggs, along with his girlfriend Haley Gibbons, orchestrated a plan to confront Roman. Gibbons lured Roman to the motel, where Skaggs was waiting. As tensions escalated, Skaggs shot Roman, killing him on the spot. The pair fled the scene but were quickly identified through surveillance footage and social media. They were arrested in Austin by the Lone Star Fugitive Task Force on March 29, 2021, and later indicted for murder. During the May 2023 trial, Skaggs claimed he acted in self-defense, portraying himself as a truthful man and devoted family figure.
I have never, ever had the pleasure of representing someone that's come entirely clean on that witness stand and told their truth.
However, Gibbons testified against him, revealing disturbing details, including Skaggs' confession about a prior murder and a past shootout.
He told me he was on parole in Hawaii for murder. He also told me that he had a shootout in Arizona.
Her testimony painted a far darker image of Skaggs.
We, the jury, assess his punishment and confinement in the institutional division for the Texas Department of Criminal Justice for a term of 60 years.
The jury took only 30 minutes to convict him and 45 minutes more to sentence him to 60 years in prison. Skaggs must serve 30 years before being eligible for parole. Gibbons, who accepted a plea deal, is set to be sentenced separately. On the night of October 16, 2017, a marijuana deal arranged in a San Antonio parking lot ended in violence. Gary Barnhart, 20, and a friend had planned to sell marijuana to Charles Robnet, Michael Aguilar, and Emmanuel Herrera. However, the meeting was a setup. Instead of buying the drugs, Robnet and the others attempted to rob the pair. During the confrontation, Robnet opened fire. Barnhart was shot and died from his injuries, while his friend was wounded. Despite efforts to get help, Barnhart could not be saved. The surviving witness later cooperated with authorities in exchange for leniency on unrelated drug charges. In November 2019, Charles Robnet stood trial for capital murder. The state presented testimony from Barnhart's friend, who recounted the failed drug deal turned robbery.
I just remember grabbing it and throwing it away from the car, away from us. There was so much smoke that Gary ended up telling me to move him over. So I did. Try to get help, and that's when I drove to H-E-B.
Though eligible for the death penalty, prosecutors chose not to pursue it. The jury found Robnet guilty, and he was sentenced to life in prison without parole. His alleged accomplices, Aguilar and Herrera, were also charged with capital murder and awaited trial. On August 9, 2016, a deeply disturbing and tragic situation unfolded in San Antonio, Texas. Andira Abdelaziz, 37, fatally stabbed her 25-year-old nephew, Ahmaud Abdelaziz, with whom she had been engaged in a secret romantic relationship for 3 years. According to her testimony, the relationship was not only hidden, but also abusive, marked by repeated physical assaults and emotional manipulation. That morning, Andira called 911 to report a disturbance involving Ahmaud. When officers arrived, they found no immediate threat and left. Shortly after, Ahmaud attempted to flee in his vehicle, but crashed into the house. He had suffered a stab wound and died at the scene. The case went to trial in 2018, and emotions ran high from the outset.
I love her, and she doesn't deserve this.
The prosecution alleged that the murder was driven by a fear of exposure, claiming Ahmaud had threatened to reveal their relationship.
Somewhere between this request for 2, the minimum, the absolute bare minimum, and somewhere out here, there's justice. And there's your message.
The defense, however, portrayed Andira as a long-suffering victim who acted out of desperation after enduring years of abuse.
She was trying to survive. She had never done anything like this before. and all the numerous beatings that she took. They're going to come up here and bully you and make you feel bad and make you try to assess the sentence that they want.
They argued the was not premeditated, but a sudden, passionate response to years of trauma.
We, the jury, find the defendant guilty of murder as charged in the indictment.
After a brief 20-minute deliberation, the jury found her guilty of murder, but ruled the act was committed in sudden passion, a legal distinction that reduced the sentencing range. In the end, Andira Abdelaziz was sentenced to just 2 years in prison, the minimum sentence possible for the charge. In January 2009, Melody Velasquez was found unresponsive in the San Antonio home of her adoptive fathers, Matthew Aranda and Norberto Velasquez. Aranda claimed she had fallen down the stairs, but an autopsy revealed she died from injuries and had multiple signs of previous abuse. Melody had been placed with the couple after being removed from her biological parents due to neglect. Her biological aunt, Petra Jimenez, had tried to adopt her but was denied custody by Child Protective Services, allegedly due to financial concerns. The girl's ruled a homicide raised serious concerns about the state's welfare system.
I have been fighting for her since day one to get custody of her through CPS, and they failed me.
Aranda was originally charged with capital murder, but was later re-indicted for lesser charges, including injury to a child by omission. In May 2014, during his trial, he fled to Mexico before the jury could reach a verdict.
If he wasn't guilty, why did he run? I want justice for Melody. I just feel that 20 years is not enough.
Despite his absence, the jury found him guilty of reckless to a child and sentenced him to 20 years, the maximum allowed. He was captured later that year in Chihuahua and extradited to the U.S. His partner, Norberto Velasquez, was also convicted but died of disease before serving his probation sentence. In September 2011, a gruesome crime shocked San Antonio when Samvastion Sammy Ochoa, her mother, Rebecca Gonzalez, and family friend Pamela Wensky were found to death in a burning home. Investigators quickly identified Sammy's father, Conrad Ochoa, and his brother Breon Ochoa as suspects. Authorities believed the murders were committed to silence Sammy, who had allegedly disclosed sexual abuse by both men. Both brothers were charged with capital murder, but the intentional fire had destroyed crucial forensic evidence, making a conviction difficult. By 2016, facing challenges in proving the murder charges, prosecutors offered plea deals. Breon Ochoa received a 55-year sentence for continuous sexual abuse of a child, while Conrad took a deal on a lesser charge and was sentenced to 10 years. The capital murder charges were dismissed without prejudice, allowing for re-indictment if new evidence emerged. Despite the brutality of the original case, Conrad Ochoa was granted parole and released in March 2017 after serving just over 5 years. His release included conditions such as sex offender registration and internet restrictions.
I'm mortified that he's going to be on the streets. I'm not sure what other measures will be in place to keep him from continuing what he has done and has been convicted of and what he's suspected of. There's still time. If somebody knows anything, report it. It could be something that maybe seems minor to you, but it could make a difference.
The victim's grandmother, Susie Bianchi Peters, voiced her fear and heartbreak, urging anyone with information to come forward so that justice could still be served. In the early hours of December 21st, 2019, San Antonio ISD Detective Cliff Martinez was working an off-duty security shift at an IHOP on the city's south side. Around 3:40 a.m., a disturbance erupted inside the restaurant. Detective Martinez stepped in to break up the fight, which spilled into the parking lot. What followed was a violent confrontation that ended in tragedy. Martinez was assaulted and then run over by a vehicle. He died at the scene. Two men, Alfredo Martinez Contreras and Jorge Armando Lopez, were arrested and initially charged with capital murder. In March 2020, both were formally indicted. However, as the investigation progressed, the Bezark County District Attorney's Office determined there wasn't enough evidence to prove Martinez Contreras was still present when Martinez was struck. This led to plea deals for both men. Martinez's grieving family expressed outrage, calling the sentence far too light for the loss they endured.
You made a terrible choice and it cost me my brother's life.
You are a monster. You were the catalyst of everything that happened that night.
The sentence you're getting today
is very, very light. I was given a life sentence on the day that my son was.
They described Martinez Contreras as a monster and told the court they had been given a life sentence of grief, while the man responsible might walk free in just a few years.
Clearly, this is not acceptable to this family. It's really not acceptable to our office, but it was what we had to work with.
You have a choice every single day of your life. I really hope you reflect on what's happened. You can change your life. You've got a chance to do that where I don't get clipped back.
Lopez accepted a 20-year sentence for manslaughter in 2022. Martinez Contreras later pleaded guilty to a reduced charge, assault of a peace officer causing bodily injury, and was sentenced to 15 years in April 2023. On April 9, 2019, the quiet of Stagecoach Lane in San Antonio was shattered by a horrific discovery. 53-year-old Mary Helen Dempsey was found brutally murdered in her home by her daughter, who became alarmed when Mary didn't show up for work and wasn't answering her phone. The scene was violent. The house appeared ransacked, and her 2016 beige Honda Accord was missing.
Got anything you want to say, man? Sorry.
As the investigation unfolded, police quickly identified two suspects, Mary's own 18-year-old son, Matthew Dempsey, and his friend, Daniel Saucedo.
A heartbreaking story it's one thing to find out that this was maybe random or somebody else, but to find out that this was actually the son of the victim involved in this, it's just kind of hard to process. But the evidence shows otherwise, and we have to go by the evidence.
According to court records and Matthew's confession, the two had planned to rob Mary's home. Using a key, they entered and began collecting valuables. When Mary unexpectedly came home, Matthew attacked her. Saucedo joined in, and together they killed her before fleeing with her credit cards and car, later using the cards at an ATM. Blood-stained clothing was found at Matthew's home, leading to his arrest. In October 2019, Matthew Dempsey pleaded guilty to murder and received a 42-year prison sentence with parole eligibility after 21 years. Saucedo's legal proceedings were pending at that time. In October 2024, emergency crews in Elizabethtown, Kentucky, responded to a house fire on Hennen Lane. Inside, they discovered the bodies of Blake France, 41, and Anthony Garrett, 43, both shot to death. Investigators determined the fire had been intentionally set to conceal the crime. Witnesses reported seeing a gold pickup truck leaving the scene, which led police to a nearby motel. Surveillance footage showed 45-year-old Dustin Caudill exiting the vehicle and later discarding a weapon. When authorities searched his motel room, they found items belonging to the victims. During questioning, Caudill confessed to the murders, the arson, and theft of the victims' wallets.
And then had already granted $7,500 to the forensic consultant. Thorn, so he needs 10 grand more. And the mitigation specialist, investigations, is what they need. Wow, they've granted $5,000. They want 20 more grand. Is that how it is? It is? Oh, yes, yes, it is. Okay, it is. All right. And you confirm that all these requested funds are the actual amounts that the individuals state to you that they needed to continue their investigation on your behalf?
Yes.
All right, I'll get those entered.
All right, thank you, Your Honor.
Is that all for the case, Mr. Brownback?
Yes, it is, Your Honor.
All right, and again, Mr. Caudill, your attorney can discuss with you. I've held what's called an ex parte hearing off the record because those are appropriately to be heard. I'll let him discuss with you anything associated with that because I don't put that on the record because again, it is ex parte. Okay, sir?
Yes, sir.
Right, thank you. We're still back. Nothing else until as far as we know, the final pretrial next year. Otherwise, if anything else comes up, Mr. Brownback knows how to bring it in front of the court, okay?
Yes, sir. Thank you very much.
Thank you.
Thank you.
Caudill was charged with 2 counts of murder: first-degree arson, robbery, tampering with physical evidence, possession of a weapon by a convicted felon, and wanton endangerment. His case drew widespread attention due to his criminal history. He had previously been convicted of his mother and brother in 1994. As the current case progressed, several motions were discussed in court regarding evidence and trial preparations. He pleaded not guilty in January 2025 and remains in custody at the Hardin County Detention Center on a $1 million bond. A trial date has been set for January 2026, where Caudill will face all charges in front of a jury. In January 2025, Breon Allen Jr. was killed in a drive-by shooting while walking alongside his 21-year-old cousin, Lafayette Mango Jr., on Jacksonville's west side. The sudden burst of shots was not random. Investigators later revealed that Mango was the intended target due to an ongoing feud between rival gangs, 6 Block and ATK. Authorities believe the shooting was retaliation for a diss track Mango had released, which escalated tensions between the two groups. While Mango survived the ambush, young Breon tragically lost his life in the crossfire. In the weeks that followed, law enforcement arrested 6 individuals connected to the case.
I don't know nothing about no shooting, so I'm sorry for their loss, and I'm an innocent man.
Dante McGee and Tavares Kelly were believed to be the shooters, along with Keith Fields, 18, Daniel Larkins, 20, Keith Johnson, 21, and Gerard Sykes, 24. All were charged with murder, attempted murder, and conspiracy to commit murder. Johnson and Larkins were also tied to a separate homicide investigation from 2024.
It's a $25,000 cash reward payout that will go to the tipster who provided this tip anonymously.
A crucial break in the case came from a tip submitted to a channel's stoppers, one of 22 leads received, which directly led to the arrests of McGee and Kelly. In recognition, the tipster received a record $25,000 reward.
At this time, we will be pleading not guilty to all 3 counts. And pleads not guilty to all counts.
All defendants were charged with murder, attempted murder, and conspiracy to commit murder. They have pleaded not guilty, and court proceedings are set to continue later in 2025. In August 2016, a chilling 911 call from Catlin Kinateder stunned the community of Sheboygan Falls, Wisconsin. The 27-year-old mother confessed to her son, Dexter. When officers arrived at her apartment, they found Kinateder armed with a weapon and refusing to drop it. After subduing her, police discovered the boy's body hidden inside a closet. During the call, Kinateder told that she had lost her mind and claimed voices in her head told her that her son couldn't live anymore.
Okay, what's the problem?
I killed my son.
You what?
I killed my son.
How did you kill your son?
I strangled him.
Anything going on with you?
I feel like I've lost my mind.
The case was immediately recognized as one involving severe mental health concerns. Kinateder was charged with first-degree intentional homicide and hiding a corpse. She later pleaded not guilty by reason of mental disease or defect, prompting the court to order a psychiatric evaluation.
And in addition, that mental disease or defect had to prohibit them from knowing right from wrong.
The defense argued she suffered from serious mental illness, including bipolar disorder and depression, and had stopped taking her medication prior to the crime. In December 2017, a judge ruled that Kinateder was not legally responsible for her actions due to her mental state at the time of the offense. She was found not guilty by reason of insanity and was committed to a secure mental health institution. On March 1st, 2021, 31-year-old Michael Dewitt committed a violent carjacking at in Simpsonville, Kentucky. While fleeing the scene in the stolen truck, he drove the wrong way down Louisville's Dixie Highway and crashed head-on into a car driven by Madeline Trout, a senior at Butler Traditional High School. The collision was fatal. Madeline died instantly. Witnesses managed to detain Dewitt until police arrived. Shockingly, at the time of the crash, Dewitt had been out on a $5,000 bond posted by the Bail Project just a week earlier, after being arrested for assaulting a police officer. In October 2024, Dewitt pleaded guilty to a federal charge of carjacking resulting in he was sentenced in January 2025 to 20 years and 5 months in federal prison, with an additional 5 years of supervised release. In a separate proceeding in March 2025, he was sentenced in state court to 20 years for murder and 5 more years for related offenses to be served concurrently. In March 2015, Anthony Brigman was driving his yellow Corvette along Mount Holly Road in Fairdale, Kentucky, with his girlfriend, 46-year-old Stephanie Goebel, in the passenger seat. Brigman, heavily intoxicated with a blood alcohol level of 0.193, more than twice the legal limit, lost control and crashed into a utility pole. Goebel, who was not wearing a seatbelt, at the scene. Brigman was initially charged with murder, but later accepted a plea deal in August 2015, pleading guilty to second-degree manslaughter, first-degree criminal mischief, and aggravated DUI.
And I scrolled through and I found these things, and what I found was that Mr. Brigman was sharing either pictures or videos of things that, to me, speak to an absolute lack of remorse. The next one is a picture of a hearse that says, and it's parked in a cemetery, it says, "Eat right, stay fit, die anyways." Just an absolute nonchalant, dismissive attitude regarding.
During his sentencing in October, prosecutors pointed to social media posts Brigman made while on home incarceration. Images and captions, they argued, reflected a dismissive attitude toward death.
He says that it wasn't a crime that he chose or that wasn't on purpose, but I go out every once in a while. It is a choice to get a drink and to get in a car. I don't do it.
Goebel's daughter spoke passionately in court, stressing that drinking and driving is always a choice.
Death is different. Death is different. And would probation depreciate her death, the manner of her death, the reason for her death? Yes, it would.
The judge agreed with the prosecution, stating that probation would diminish the seriousness of Goebel's. Brigman was sentenced to 7 years in prison and taken into custody immediately after the hearing. In August 2013, Elizabeth Stakelbeck of Louisville, Kentucky, devised a plan to have her ex-husband, Matt Vaughn, and his new wife, Morgan Vaughn, murdered. Believing her daughter was in danger and reportedly under the influence of prescription drugs, Stakelbeck approached someone she thought was a hitman and offered cash, pills, and favors in exchange for the killings.
I lost all my humanity. I became something I didn't recognize.
She provided photographs, detailed notes on the couple's routines, and descriptions of their vehicles. However, the man she tried to hire turned out to be an undercover FBI agent. Her plan was quickly exposed, and she was arrested before any harm could be done. In March 2014, Stakelbeck pleaded guilty to charges including solicitation to commit murder and trafficking.
I was convinced in my mind that my child was in danger, and I felt like I had to do what I had to do to protect her.
The problem with these sentiments is that I've heard each of them before and on many occasions.
During her sentencing, she expressed remorse, but the victims described the lasting fear and emotional toll caused by her actions.
I will never forget seeing the evidence for the first time. My wedding pictures were used to identify us to the hitman. Pictures that I should look at and remember the happiest day of my life are now marked with her intentions to kill us. My family deserves to live our lives absent of fear and paranoia that has been created because of her actions.
The judge denied her request for probation, stressing the seriousness of the crime. She was sentenced in May to 15 years in prison and fined $1,000. In January 2015, she applied for shock probation, an early release option, which was also denied, solidifying the court's firm stance against attempted contract killings. On the afternoon of February 23, 2020, 25-year-old Ahmaud Arbery went out for a jog through the quiet neighborhood of Satilla Shores, just outside Brunswick, Georgia. It was a familiar route, just a few miles from his home. As he passed by houses in the area, two men, Gregory McMichael, a retired investigator for the local district attorney, and his son, Travis McMichael, a former Coast Guard member, noticed him running. The McMichaels claimed they believed Arbery resembled someone suspected of recent break-ins in the neighborhood. Although no no reports or evidence linked him to any crime that day. Acting on their suspicion, they armed themselves and pursued Arbery in their pickup truck. A neighbor, William Roddy Bryan, saw the commotion, joined the chase in his own vehicle, and began recording the pursuit on his cell phone. The men followed Arbery through the streets, attempting to cut him off several times. Arbery, unarmed and on foot, tried to avoid them. Eventually, the McMichaels stopped their truck ahead of him. As Arbery approached, he encountered Travis McMichael standing outside the vehicle with a weapon. A struggle broke out between the two, and in a matter of seconds, Travis fired his weapon. Arbery was struck and collapsed to the ground. Despite the deadly outcome, none of the three men were arrested immediately. Gregory McMichael's connections to local law enforcement complicated the situation. The first prosecutor, Jackie Johnson, recused herself due to a conflict of interest. The second, George Barnhill, also stepped aside after defending the McMichaels' actions in writing. It wasn't until a third prosecutor, Tom Durden, took over that the case began moving forward. For over 2 months, Arbery's death received little national attention. That changed on May 5th, 2020, when Brian's cell phone video was leaked and spread rapidly online. The footage, showing the final moments of Arbery's life, sparked outrage across the country and intensified demands for justice. Just 2 days later, the Georgia Bureau of Investigation stepped in. On May 7th, both Gregory and Travis McMichael were arrested and charged with felony murder and aggravated assault. Brian was arrested later that month and charged as a party to the crime. The case went to trial in November 2021. Prosecutors argued that Arbery was pursued and killed without justification, and that the chase had been driven by racial bias. They emphasized that Gregory McMichael played a central role in initiating the encounter, arming himself, encouraging the pursuit, and then attempting to control the narrative afterward by making inflammatory statements and providing inconsistent accounts to the police. The prosecution maintained no immediate threat, no crime in progress, and no legal basis for a citizen's arrest.
All right, we are going to talk about Greg McMichael. Greg McMichael did attempt to control the narrative after this took place. He's the one who started this whole thing, and now his son has killed someone. And that young man is laying dead in the street from these shot blasts. So what does Greg McMichael do? Well, while first responders are on the scene, he's going up and he's telling his kid, you didn't have any choice. He goes over and he talks to Brian to find out what he saw. Oh, he's got a video. He goes over and he talks to Diego Perez. He's outside the crime scene tape, wandering around, talking to people. Someone brings him his phone. A stranger comes up to him. Some neighbor comes up to him. I mean, this is a crime scene. There is a young man in the middle of the road, and strangers are walking up to him, and what does he tell this stranger? This guy ain't no shot. This guy's an asshole. Malice, right there.
In contrast, the defense claimed the men were lawfully attempting to detain someone they believed to be a suspect in local trespassing incidents, and that Travis McMichael fired in self-defense during a physical struggle. Travis took the stand in his own defense, telling the jury he acted out of fear for his life, though prosecutors challenged this claim by pointing out that Arbery was unarmed and had committed no crime when he was confronted.
While giving the statement.
I just killed man. I had on me still. It was the most traumatic event of my life. I was scared to death. I mean, it was the most traumatic event of my life. I don't know anybody who wouldn't be scared or stressed or terrified or anything. I mean, it was horrible.
I'm talking about giving your statement 2 hours later at a police station. You were nervous because you thought you were going to jail, right?
No. I gave him a statement. I mean, if I would have,
somebody and you don't think you're going to jail. Is what you're saying?
I was going through an investigation. I was following the investigation.
So, you saw Officer Duggan's body cam, correct? Officer Duggan, the first officer who testified, his body cam?
Yes, ma'am.
All right. You were standing right behind Officer Duggan while all that went on, right?
Yeah, I guess. Yes, ma'am.
Okay. So, you've just shot Mr. Arbery 3 times with a shotgun, correct?
Correct.
He's on the scene, correct?
Correct.
He's unarmed, correct?
He was.
All right. And your father came up to you and grabbed you by the shoulders and went, you had no choice, you had no choice, right? You saw that?
Yes.
All right. You're covered in Mr. Arbery's blood. You go down to the police station, correct?
Correct.
All right.
here?
No.
Let's keep going.
Okay. And at that point, you're in the safety of the police department giving your statement, correct?
Yes.
All right. You got all the time in the world, correct?
Yes.
All right. And Detective O'Hilly hasn't threatened you,
No,
hasn't forced you to make a statement,
he did not.
okay, and didn't promise you anything in order to get you to make the statement.
I'm gonna look real quick. He did not.
Okay. But you're telling this jury that you're all confused and you can't get the facts straight as you're telling the police about why it was you shot and killed a man.
I was trying with my best ability, but like I said, under the circumstances of going through a traumatic event, this is the most traumatic event that I have ever been through in my life. I don't know how. I've never been through a situation like that, so the reaction, trying to go through and trying to be as factual and tell as detailed as I could, and then looking through the transcript and being scattered as it was, I could tell that obviously I failed attempting to try as best I could. It just, this is what you got. I tried, and this is what happened.
So, fair to say you never told Detective O'Hilly nor wrote down in your written statement that you told Mr. Arbery the police were on their way?
It seems that I attempted to say it in these words here.
And at that point, Mr. Arbery turns around and runs back down Burford to get away from you, correct?
That's correct.
So at this point in time, he's running away from you. He has not threatened you.
No.
Hasn't pulled out a gun.
No, ma'am.
Hasn't pulled out a knife.
He did not.
Still arms at his sides.
That's correct.
And he's trying to get away from you.
And I was letting him run away. Yes, ma'am.
You were letting him run away.
That's correct.
Wasn't it your intention to go around the block and cut him off and find him over on the other side?
To head him off and to see where he's located. That was my intention, yes, ma'am.
All right. But you could have stopped right there and not done anything, right?
Yes, but then immediately after is when I saw his interaction with the black truck and realized that there is something to my suspicions here, and I would like to see where he is at when the cops come, which I assume that the police were on the way, that I would be able to tell them where he's at if they haven't located him at that point.
So you're telling this jury that your whole intention was just to go ahead and follow Mr. Arbery, keep an eye on him, and to just tell the cops there he is?
At that point, yes, ma'am.
Now, it's true that your father, while in the truck with you, going down Burford towards that end, was yelling at you, cut him off, cut him off, cut him off, right?
He was talking to me or was telling me, I don't know if he was saying cut him off or not. I know that he was saying there he is, that's the guy. After that, I am not sure exactly what he said.
At this point, you're still yelling at Mr. Arbery to stop at the end of Burford.
I was not yelling at him on Burford, no, ma'am.
And at the end of Burford, you and your dad both got out of the pickup truck, correct?
When he turned and started running down Burford, when he was away, when he was not a threat, if he wanted to be a threat and he was going past that, yeah, I got out of the truck, yes, ma'am. When he turned and running away is when I got out of the vehicle.
Why in the world would Mr. Arbery be a threat to you?
Because of when I asked him what was going on and recognized that it was the guy that I saw on the 11th and Mr. Albenzi pointing and everything going down and realized that it is him, and then how he reacted when I shined the lights on him on the 11th, he acted like he did not want to be He was obviously caught sneaking through the front yard. He was obviously where he wasn't supposed to be, where he hasn't been several times, and then he reaches into his pants like he has a gun, and that, I took that as a threatening gesture and walked in the house. Now it's the same guy on the 23rd that I've just pulled up to that turned out my father was correct. People pointing down the road, the same scene that this happened 12 days prior, that yes, there was a possibility that he may be armed with that gesture, but he didn't show me that, and he started running down the road. I was no longer under a threat if there was to be one, so I got out of the vehicle after my father got out of the vehicle to see what was going on and watch.
After weeks of testimony, the jury found all three men guilty. In January 2022, they were sentenced to life in prison, with Gregory and Travis McMichael receiving life without the possibility of parole.
That said, with regard to the sentence in this case, as to Travis McMichael, Mr. McMichael, the court sentences you as follows. Count 1, malice murder, life without the possibility of parole. Count 2, felony murder, is vacated by operation of law. Count 3, felony murder, vacated by operation of law. Count 4, felony murder, vacated by operation of law. Count 5, felony murder, vacated by operation of law. Count 6, aggravated assault, merges into count 1. Count 7, aggravated assault. The court sentences the defendant to 20 years consecutive to count 1. Count 8, false imprisonment, merges into count 1. Count 9, attempted false imprisonment, 5 years concurrent to count 7. That is life plus 20. Greg McMichael, the court sentences you as follows. Count 1, malice murder, defendant was found not guilty. Count 2, felony murder, life without the possibility of parole. Count 3, felony murder, vacated. When I say vacated, it's vacated by operation of law in all cases. I'm not going to repeat it. Count 4, vacated. Count 5, vacated. Count 6 merges into count 2. Count 7, aggravated assault, 20 years consecutive to count 2. Count 8, 10 years concurrent to count 7. Count 9, 5 years concurrent to count 7. That is life plus 20 years. Roddy Bryan, I do want to separate a little bit because the state is making a different recommendation. And despite the back and forth that Mr. Goff and I had during this case, I do want to point out a couple things that he raised that I think are appropriate to raise with regard to the sentence. As far as the remorse, I think Roddy Bryan stands in very different shoes. It is obvious from the beginning that he questioned the tragedy that had occurred at the scene and was on, I believe, I can't remember whose body cam, but the body cam, in fact, questioning whether or not what had occurred, and then took steps early on in this process, I think, that demonstrated that he had grave concerns that what had occurred should not have occurred. And I think that does make Mr. Bryan's situation a little bit different. However, Mr. Bryan has been convicted of felony murder. And I do not believe it can be disputed based on the facts of this case, that the verdict was an appropriate verdict based upon the evidence presented, at least. And when I say appropriate, what I mean is legal. Because I believe there's been some discussion about some differences between Mr. Bryan and the McMichaels. There may be some differences, but it does not change the fact that was it not for the fact that Mr. Bryan used his vehicle in a way to impede Mr. Arbery's course of travel, this may not have ever occurred, and that is sufficient for felony murder. He did cooperate with law enforcement. I will point out Mr. Goff, 1710-1B. There's actually a case out of Chatham County that says it would not apply under the circumstances of this case. So the court recognizing that Mr. Bryan's position is different. Again, Mr. Bryan was found not guilty on count 1 and count 2. The court sentences Mr. Bryan to life with the possibility of parole on count 3. Count 4 is vacated. Count 5 is vacated. Count 6, the defendant was found not guilty. Count 7 merges into Count 3. The defendant is sentenced to 10 years consecutive to Count 3 on Count 8 and 5 years concurrent with Count 8. Both of those counts, though, will be suspended sentences, which gives Mr. Bryan a life with the possibility of parole sentence.
Soon after, the three men were also tried in federal court on hate crime charges. In February 2022, a federal jury found that they had targeted Arbery because of his race. They were convicted on all counts. The case didn't end there. Former District Attorney Jackie Johnson was later indicted for violating her oath of office and obstructing law enforcement, accused of interfering with the investigation and favoring Gregory McMichael. Her trial is scheduled for 2025. On a rainy morning in April 2022, 26-year-old Patrick Lyoya was driving through a neighborhood in Grand Rapids, Michigan, with his friend Aye Toshimi in the passenger seat. Earlier that day, they had visited Patrick's new apartment, picked up a third acquaintance, bought some drinks, and were driving around casually. At some point, a Grand Rapids police officer, Christopher Schurr, noticed the license plate on Patrick's vehicle didn't match the registration and initiated a traffic stop. Patrick stepped out of the car before the officer approached, prompting the officer to ask him to return to his seat. Due to a language barrier, Patrick's first language was Swahili. There appeared to be confusion. He looked inside the vehicle for his license, but didn't produce it. Then, he started walking away. Officer Schurr followed, informing Patrick he was being detained. Patrick briefly pulled away and moved toward a nearby lawn. The officer attempted to restrain him, and a physical struggle followed. During the encounter, the officer attempted to use his taser device, which did not result in control. At one point, Patrick held onto the device, leading to further struggle. Multiple videos captured from a body camera, a dash cam, and a bystander's phone showed the two moving across a front yard during the struggle. Eventually, Officer Schurr took control of the situation. In a moment captured on camera, the officer used his department-issued firearm, resulting in Patrick's death.
Good morning once again. Single wound right to the back of the head. That's what killed Patrick Lyoya on a cold, wet, rainy day back in April 2022. It's almost in the middle, maybe a little bit below the middle. You have an opportunity to see it, I think. But that single wound is what killed him that day. It's not just me saying that. You're going to hear from Dr. Stephen Cole. He's our medical examiner, and he's going to say he can determine that because when a bullet is fired, the bullet comes out, it comes out in that puff of smoke, and that puff of smoke contains some residue. Now, from far away, you're not going to get residue on anything, but if it's a close shot within a few feet, you're going to be able to tell unless that barrel was in contact or near contact with the back of the head of the individual. And he's going to tell you it was a contact or near contact wound that killed Patrick, the barrel of the gun on the back of the head. Now, it's not just you have to rely on his testimony about that either. You have an opportunity to see the video. You'll see the video where the defendant who sits before you here today fired that shot. It's on a cell phone video. So to some extent, your job is somewhat easy because you're going to have more video and access to different videos than just about any jury that's ever been around. You'll have a cell phone video. You'll have a body camera video. You'll have an in-car video. You'll have a security camera video from across the street. You'll see different versions of the video in terms of freeze framing videos. You'll have an opportunity to see everything and break this down video by video. One of the troopers, Zach Batchelor, he synchronized these videos. So you have all the videos together when you go to deliberate this case. You have to watch this over and over again, probably more than you wish to. But it's an important piece of evidence. But that's not the only evidence because, as I said, there's evidence that comes from the stand as well. And we'll call witnesses. And it starts out fairly simple because we're going to start out with David Courtroom. He was a friend of Patrick's. He was, Patrick spent the night at his apartment before he left that morning. Dave's going to tell you he was hanging out with Patrick. Patrick and him had gone back. They're both African immigrants. They had been together for a few years. They know each other. He spent the night. Ahmaud Arbery is the other person that was at the apartment. I think him and David were actually roommates at the time. And Ahmaud is the one who actually took the cell phone video that morning. David says, yes, they hung out, they're drinking, having a good time, nothing special, just kind of hanging out like guys do. And so that morning, he had to wake Patrick up. Patrick had told him the night before, he slept on the couch, hey, wake me up, I gotta leave before 8 o'clock, I got something to do. Now there's another individual, Amark, David doesn't remember him, Ahmaud does, kind of says, yeah, we had to take him to his house or had to take him to work, but just before 8 o'clock, he was gonna say, yeah, we woke him up, Patrick's gotta leave, he left with Ahmaud, they get in Patrick's car and take off. Now Ahmaud's gonna tell you, yeah, there was this guy, Amark, we dropped him off in his house, and then we went to see Patrick's own place. Patrick had his own apartment, so they went to Patrick's apartment to kind of check it out. He had just got it, he was kind of excited about it. So they looked at Patrick's apartment, and then they proceeded to leave again, and were driving around. They're gonna hear they stopped at like a Walgreens and got some beer. They got some beer, and then they got back in the car and were driving around. Now from Ahmaud's perspective, he's the passenger, Patrick's driving his car, sitting in the passenger seat, he's all of a sudden notices there's noises. There's noises going on in the car. The car is making a noise. This isn't like this is an old Nissan Altima or something like that. It's not a great car. So there's noises, and Patrick comments like, what's going on? There's noises, and Patrick pulls over the side of the road. He gets out. Now May's kind of at this point in time, not really paying a whole lot of attention. He's on his phone. But you're going to find out at that point in time, the defendant, as a Grand Rapids police officer, had pulled him over, was in the process of pulling him over. Now, from a lot of what you're going to get now is coming from the actual body cam, the body cam that's on the officer. Okay? They've got, it's on, I think it's on his chest, essentially. It's activated when the overhead lights go on. So at the time Patrick's pulling over, the officers turn on his lights, and Patrick gets out of the car. And you're going to see this interaction between the officer and Patrick at that point in time. Patrick's like, what did I do? And the officer says, get back in the car. The defendant says, get back in the car. What did I do? Now you're going to notice at that point in time that Patrick's first language is Swahili. And there's a definite accent. So the defendant, do you speak English? Patrick says, yes. But the plate doesn't match the car. And that's true. You're going to see evidence that the plate belonged to a Ford Fiesta. This was a Nissan Altima, so the plate did not match the car. Do you have your driver's license? I need your driver's license. Yes, I have one. Patrick opens the door, looks in, and Ahmaud's in there, and Ahmaud doesn't remember a whole lot, but they look, apparently maybe tries to open the glove compartment box. You can kind of see that from the video. Opens the glove compartment box and looks in there, but there's no driver's license. So Patrick shuts the door. Now they're standing in the road, it's a residential area, and Patrick starts to just simply walk away. The defendant grabs him and says, nope, 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 you're under arrest, and Patrick breaks free. Breaks free, kind of does a spin move, and then runs around the back of the car. You'll see this on the video, on the body cam video, and runs around the car. He's wearing flip-flops, and his pants are falling down, and it's kind of raining, and he runs, he gets all the way to the driveway that the car was in parked, maybe 5 yards, 10 yards at most away. It's like a 6-second chase. The defendant tackles him from behind, takes him down, and then there's a struggle. There's a wrestling match going on at that point in time. The defendant's telling him, stop resisting, stop resisting. Patrick is then trying to get out. Now you're going to hear from Wayne Butler. Wayne Butler is the homeowner where the driveway where this initial tackle takes place. This is a residential area. He's going to say it's kind of unusual for a car to get pulled over in a residential area. It's surrounded by Kalamazoo and some busier streets. And he's kind of, that's kind of weird to see a car getting pulled over there. So he actually goes out. You'll actually see him on the cell phone video now, because at this point in time, Ahmaud realizes what's going on, and he gets out of the car and starts videotaping on a cell phone. So now you have a combination of someone's going on a body cam, you get some from the in-car video, you also have the body cam.
An autopsy later confirmed that the fatal injury occurred at close range. This incident sparked protests and public outcry, leading to an investigation by Michigan State Police. In June 2022, Officer Schurr was charged with second-degree murder. He was later dismissed from the police department. The case went to trial in April 2025, where the central question was whether the use of force was necessary under the circumstances.
There are two experts say, well, the ability of Patrick to do anything was not there because he couldn't shoot the taser. The taser had been shot. The drive stun doesn't cause. So there was no intent, there was no ability to cause any sort of harm to the officer. But they also take a look at the officer. The officer's perspective, you kind of take a look at the officer is a reasonable officer, is a reasonably intelligent officer, and then who's prudent in same or similar circumstances. Would that officer anticipate needing to use force, the force against the person? And you look at all the facts and circumstances, because that's what you got to do. Reasonableness and all the facts and circumstances presented to the officer at the time. A reasonable officer in that situation would not think death was going to happen, would not think the use of deadly force was necessary, because that's what it's got to be. It's got to be necessary. Police officers can arrest. That's not the issue. Here. We're not saying he shouldn't have been arrested. Patrick committed crimes. There's no question about that. He committed the crime. He was driving without a license plate. He was, didn't have a driver's license. He resisted arrest. He pulled away. You're gonna also find out that he was probably drunk driving too, because his blood alcohol level was like a 3.0 at the autopsy. Okay, so he was drunk driving. So it's not an issue of if the defendant had the right to arrest him. The issue becomes, did he have to kill him in the course of trying to arrest him? I think when you look at all the evidence, you look at the you come to a conclusion. The answer is no. Because what the judge just said, I have to prove things. I break it down into 4 things. I have to prove there's a death. That's your checklist. Was there a death? Well, that's 100% certain. There's a death. Patrick's dead right now. I have to show that the death was caused by the defendant. That's 100%, no question in your mind. He shot him in the back of the head. The third thing, there's 3 different areas. There was an intent to kill. When you put a gun to somebody's back of the head, there's an intent to kill there. So those are the 3 things, are 100% you. There's no question. What your issue is and what this trial is about and why you have to decide is that 4th thing or 3rd thing. Was it justified? Was it excused? Or was it lessened to some other crime? When you talk about justified, there's a legitimate good reason for it. Excused as well. We'll give it, yeah, you did all this, but no, it's okay. We're going to give you a pass. When you take a look at that, when you put all this together, take a look at all the evidence, you have to say it was not justified. It was unreasonable. Patrick never had an intent to do any harm to the defendant. He never intended. The evidence is going to show he never wanted to do anything other than get away that day. And even if somehow he did, he didn't have the ability to cause any great bodily harm because that taser was not going to do anything. So what this boils down to is it was unjustified and unreasonable. It was a crime. It was a crime here. The defendant committed the crime of murder. A police officer can't commit murder. They're no different than anybody else. They're no different than any citizen. They can commit murder, and that is what happened back in April of 2022. The defendant committed the crime of murder. When you listen to all the proofs, and you go back and deliberate, we're going to ask that you return a verdict of guilty to second-degree murder. Thank you.
The prosecution argued it was not, pointing out that the taser had already been discharged and could no longer function effectively.
All right, so we talked about incapacitation. What you don't talk about is whether or not do you have an opinion on whether or not the drive stun can cause bodily harm in a situation where a person has taken an officer's taser, as in within a foot or 2 of the officer?
So when you say bodily harm, can you give me a reference by what you mean with bodily harm?
Like being blinded or getting hit in the throat and the trachea collapses.
I would assume that those things could be possible with that taser and drive stun.
Okay, so in a situation such as this, where the taser is close to the officer, is it reasonable for him to fear that he could be harmed in those ways, given the situation?
Again, it's possible, but anything is possible. I didn't see anything in the facts of this particular case that would lead me to believe that a reasonable officer would have felt that that was an immediate threat at the time deadly force was applied.
Well, Mr. Leolia in this case had switched the taser from his left to his right hand. You're aware of that, right?
Yes.
Okay. And he had it in exclusive control over it in his right hand, right?
When you say, again, exclusive control, I don't know what you mean by that. His hand was on the taser. He never had his hand in what I would term as fire control, or in the way that an individual would commonly hold it to activate it to cause either drive stun in this case with the condition the taser was in.
Would that make a difference to you if Mr. Leolia was holding it like would that change your opinion?
It would influence my opinion. I've had cases where that has been the circumstances.
Nothing further. Thank you, Your Honor.
You kind of right to one opinion. You said one of his questions was that, well, your opinion is based on the taser's not in a condition to incapacitate him. And you said, well, that's part of my opinion why the use of force is not appropriate here. What's the other part, I guess? What is missing out of that opinion? It's not just the taser. What else is there?
So when we talk about any application of force within policing, it's based upon a number of factors. One is proportionality to the resistance or threat that an officer perceives. During this entire instance, while I talked about the other applications of force that a reasonable officer would have used throughout this situation as it unfolded, the primary form of resistance that was demonstrated by Patrick Leoya would be classified as resistance. And so resistance in the form of physical resistance, attempting to get away, being taken into custody, creating distance. Not at any time in any of the evidence that we reviewed did we ever see Patrick Leoya attempt to harm the officer in this particular instance. As noted, Patrick Leoya did grab a hold of the officer's taser, and there was a struggle over the taser in this instance. But again, in this circumstance, it is that there was nothing that we term to be aggressiveness or combativeness on the part of Mr. Leoya towards the officer in this case, coupled with the fact that the taser is not in a condition where neuromuscular incapacitation could be achieved, in addition to the fact that a reasonable officer would have known that that was the condition of the taser. And so all of those things together would lead a reasonable officer to conclude that they do not have grounds to reasonably articulate that they were under an immediate threat of receiving great bodily harm, great bodily injury, and or therefore that classifies the application of deadly force in this instance as unreasonable and excessive.
Thank you. I have nothing further. Any couple more questions on that?
Does an officer have to wait to be harmed before he acts?
They do not.
Okay. And it's your opinion that you never saw any act of aggression by Mr. Leoya on those videos?
No.
That's not your opinion, or you didn't see any?
My opinion is that we did not see any actions by Mr. Leoya that we would constitute as act of aggression attempting to harm the officer.
Expert witnesses like Nicholas Bloomfield and Seth Stoughton explained that the device at that point could not cause serious harm.
Your Honor, good morning. So at this time, the defense would be moving for a mistrial based on the evidence that has been presented so far. This is based. Yes. And this is based on the evidence that was presented in the prosecution's case in chief. And we believe that the evidence presented will prejudice the defendant to the extent that the fundamental goals of accuracy and fairness are threatened. By allowing Mr. Stoughton and Mr. Bloomfield to opine on standards that are not applicable under Michigan law. As they both admitted, they don't know what Michigan law is, and that are not within the knowledge and in the situation of the arresting officer, based on tactical considerations that are not ultimately at issue in this case, including everything that led up to the ultimate issue here, which is whether Officer Schurr had an honest and reasonable belief to be in fear of death or great serious bodily injury at the moment that he made the decision to use deadly force. We also, based on their testimony, it's clear that they have not relied on proper training. They were relying on outdated policies. They were testifying about a taser model, an old taser model. They were not qualified as taser experts, and they gave several opinions about the taser. And at this point, we believe that we're too far along with the jury to simply strike the testimony, because they have heard testimony from two of the people's experts now that do not accurately, and are not nowhere near based on what the law is in Michigan and what should be considered in whether or not Officer Schurr was justified in using deadly force. And And so at this time, we would move for a mistrial on that issue. And if the court is not inclined to grant the mistrial, then we would be asking that their testimony is struck from the record. Although we don't think that would be enough because they've heard too much now based on the tactical considerations.
The defense maintained that the officer acted in self-protection, believing he was at risk. After days of testimony and video analysis, the jury could not reach a unanimous verdict. On May 8, 2025, the judge declared a mistrial. Patrick's and the events that followed remain a focal point in ongoing conversations about police conduct, the use of force, and accountability. Prosecutors now face the decision of whether to retry the case in the future. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.